Friends, I welcome you all. In last lecture of this course titled as Hindu Personal Law, including marriage and succession. Friends, we discussed each and every topic of the Hindu law and we focused on the succession and marriage. Friends, in today's class, I am going to focus on the specific provisions of the Adoption and Maintenance Act, which focused on the maintenance of wife, widow, children's, aged and infant parents, and dependents. Friends, before starting today's lecture, I want to summarize what I discussed in the last class. In the last class, we understand the concept of the maintenance, which is wider enough, and you understand that the idea of maintenance developed under the Hindu Adoption and Maintenance Act play a very crucial and pivotal role in order to develop the entire concept of maintenance under the Indian legal system. Friends, the idea of maintenance is also given in section 24 and 25 of Hindu Marriage Act and also section 144 of Bharatiya Nagarik Suraksha Samhita 2023. Friends, we try to accommodate everyone in the last class, and very progressive judgment passed by Supreme Court in February 2025, where the 3 judges bench of Supreme Court concluded that wife of void marriage may also claim maintenance under section 25 of the Hindu Marriage Act. Means, if by any condition, if marriage is ipso facto void, but wife is still relevant to call the maintenance. And in the light of this, friends, I want to introduce you the learning objectives of this lecture. The learning objectives includes the provisions related to maintenance for the wife, maintenance of the widow daughter-in-law, maintenance of the children and aged parents, maintenance of dependents, and meaning of dependence. Friends, now I want to focus on section 18, which is very relevant for the purpose of the Hindu Adoption and Maintenance Act, which focused on the maintenance of the wife. Friends, section 18 provides that subject to the provision of this section, a Hindu wife, whether married before or after the commencement of this act, shall be entitled to maintained by her husband during her lifetime. So long as the wife exists, shall be entitled to maintained by her husband during her lifetime. A Hindu wife shall be entitled to live separately from her husband without forfeiting her claim of maintenance. If he is guilty of desertion, that is to say, of abandoning her without reasonable cause and without her consent or against her wish, or willful neglecting her. B. If he has treated her with such cruelty as to cause a reasonable apprehension in her mind that it will be harmful or injurious to live with her husband. If he has another wife living, if he keeps a concubine in the same house in which his wife is living or habitually reside with a concubine elsewhere, if he has ceased to be Hindu by conversion to another religion, if there is any other cause justifying her living separately, a Hindu wife shall not be entitled to separate residence and maintenance from her husband if she is unchaste, ceased to be Hindu by conversion to another religion. Friends, so now I want to explain you the interpretation of section 18. Section 18 subclass 1 impose obligation on husband, and the obligation of husband is absolute and personal. Friends, the act does not say that husband has a duty to maintain the wife, and to the extent she is unable to maintain himself out of her own estate or income. It is clear from this that the husband is under the absolute obligation to maintain her the obligation is personal in nature. It arises not from the contract express or implied, but from very nature of conjugal relationship between the husband and wife. It does not depend upon whether a husband has sufficient means to provide for the maintenance. His imperative duty to fulfill the obligation. It is not considered as a matter of grace or generosity. It follows form of spiritual relationship between the husband and wife. Friends, section 18 is not use the language husband have a duty to maintain the wife. The language is wife is entitled to be maintained by her husband. Means wife have right, husband have obligation. This is the point which should be clear. You may understand the entire concept in the notion of Half-Heldian discourse. Wife is right. It is immaterial that husband have any kind of means or not. Friends, the court will certainly take into the account of the economic condition of the husband while determining the amount of maintenance, but it cannot forgive him totally of the obligation. A wife cannot be denied the right to maintenance simply because there is an arrangement between them to live separately. Such an arrangement does not put an end to the marital relationship, and therefore while wife is living separately with consent, husband is bound to maintain the wife. Friends, in a case S.R. Batra versus Taruna Batra 2007 Supreme Court, it is held by Supreme Court that a wife can make claim for accommodation or matrimonial home only against her husband, not against any relations of the husband's, for example his parents. The amount allowed for maintenance should be adequate. Where the appellant court find it insufficient, court may increase the amount. Maintenance to be a charge. Friends, the court may create charge on the property or the salary of the husband for the payment of maintenance to wife. It may be so even on agricultural property. It may be secured by a bank guarantee. Friends, now lies very clear and simple. Section 18 imposes liability on the shoulder of husband and right in the favor of wife. Wife is entitled to be maintained by her husband. This is the language of section 18. Yes, it is of course the court will consider the economic health and economic condition of the husband when the court is going to determine the amount. But it not mean that husband in any case may immune from this liability. Husband in every case liable because this liability is personal in nature. Personal in nature means whether you have resource or not is immaterial in that context. Friends, now the fundamental point. Section 18 of Hindu Adoption and Maintenance Act focus about the validity of marriage. There be a valid marriage for the award of maintenance under this section. The Patna, Mysore, Delhi High Court are of the view that woman is entitled to maintenance from a man as a wife only when there exists a valid marriage between them. Again friends, these interpretations how long can sustain I don't know, because recently Supreme Court altered the decision where Supreme Court granted the maintenance to a wife where the marriage between the husband and wife declared void under section 11 of Hindu Marriage Act. But in a case of C. Obula Konda Reddy, Andhra Pradesh High Court full bench held that when the marriage of the claimant is void, she is not entitled to maintenance under section 18 of Hindu Marriage Act. Even though she may get alimony under section 25 of Hindu Marriage Act, she cannot be given relief in a proceeding initiated under the provisions of Hindu Adoption Maintenance Act. The principle of justice, equity, and good conscience also cannot be invoked in her favor, since the subject is covered by the legislation. Friends, but the court further held that the mere solemnization of marriage is sufficient. The woman who become a wife by such solemnization is entitled to maintenance from the husband, even if the marriage is otherwise invalid under the Hindu Marriage Act. And therefore, friends, you can correlate this interpretation by the recent Sukhbir Singh case, which is decided by Honorable Supreme Court in February 2025. Friends, in Sukhdev Singh versus Sukhbir Kaur 2025 Supreme Court has held that permanent alimony and interim maintenance can be awarded under Hindu Maintenance Act, Hindu Marriage Act 1955, even if the marriage is declared void. The court emphasized that granting such relief depends on the specific circumstances of the each case. This case may work as a guidance under section 18 of Hindu Adoption and Maintenance Act 1956. Means, friends, under the Hindu Adoption and Maintenance Act, divorced wives are not entitled. Where the marriage is dissolved, divorced wife cannot claim maintenance under this section. They may claim maintenance under section 25 of Hindu Marriage Act. In Ramchandra Behra versus Snehalata, the Odisha High Court held that the respondent sued for maintenance under section 18 of this act. The appellant pleaded that had obtained the decree of divorce against the respondent and that he had also remarried, that the respondent was not his wife and maintenance wife, and therefore she was not entitled to maintenance from him. The respondent alleged that the decree of divorce was obtained by fraud. The court held that the view of the decree of the court, the right of the respondent to get maintenance was not established unless she proved that the decree of divorce was a fraudulent one. She could not be taken to be wife of the appellant any longer. Friends, how we can interpret the entire idea? If divorced wife is claiming maintenance under Hindu Adoption and Maintenance Act, she cannot be considered fit for this purpose. Divorced wife may claim under Hindu Marriage Act. Friends, the provision is prospective and retrospective both. The language of section 18 subclass 1 make it clear that Hindu wife, whether married before or after the commencement of this act, may claim such right. Now, friends, I want to focus on section 18 subclass 2. Section 18 subclass 2 talks about the circumstances under which wife may claim maintenance while she are living separately. This is generally known as living separately but claim the maintenance. It is primary duty of the husband and wife to each other that they should live in the comfort of each other. But it is not an absolute rule. There may be circumstances due to which it may not be practically possible for both of them to pull on together or for one of them to live with the other. The statutory Hindu law therefore provided for such a situation that they can live separately in certain condition without dissolving their wedlock. Section 10 of Hindu Marriage Act makes a provisions for this, under which either spouse can petition to the court for judicial separation. Subsection 2 of section 18 of this act also makes a somewhat similar provisions, according to which a Hindu wife may obtain a decree to reside separately from her husband and also receive the maintenance from him. Means, friends, as per the traditional Hindu law, husband and wife should live together. But now 18 subclass 2 talking about situation where both are not living separately. Wife awarded a decree or any kind of order, she is entitled to live separate, but she cannot forfeit the claim of maintenance. So what are those circumstances and ground on which wife is free to live separate and enjoy the maintenance? What are those grounds? Friends, these grounds are associated with husband. Husband committed certain fault and mistake, and therefore wife become entitled to live separate place and claim maintenance. The first is desertion. If husband deserted the wife, then wife have a right to live separate and claim maintenance. If husband treated the petitioner wife with cruelty, then wife have a right to live separate and claim maintenance. The third is, friends, another wife leaving. If husband have more than one wife leaving, then wife is entitled to live separate and claim maintenance. Concubine. If her husband keep a concubine in the same house or habitually live with a concubine elsewhere, she can live separately and still claim maintenance. The conversion of husband. If husband converted into other religion, wife is entitled to live separate and claim maintenance. She can also live separately if there is any other justifiable clause, friends. Friends, in the case of Datu Bhau versus Tarabai, the Delhi High Court held that it would also seem that subsequent resumption of cohabitation might not put an end to a decree of maintenance. The case of Bai versus Haribhan, Bombay High Court held that where the husband keeps a mistress in the same house in which his wife is living, or where it is shown that the reside habitually with such concubine, the wife is entitled to leave, the wife is entitled to have the lead. The appeal filed by wife was allowed in the case. Friends, now the fundamental question is, when wife is entitled, when husband committed certain fault, desertion, cruelty, another wife leaving at the time, conversion, or any other justifiable reason. How we can explain any other justifiable reason? Suppose under section 10, wife, a decree of judicial separation is granted in the favor of wife, then it is not obligatory to a wife to live with husband, but she can claim maintenance. But section 18 also impose restrictions in which circumstances wife is not entitled to claim maintenance, and which includes when she is unchaste or cease to be Hindu by conversion into other religion. In both the cases, wife cannot claim maintenance. So therefore, friends, I discussed the rule of section 81, 82, 83. 18.1, wife is entitled to be maintained by her husband. Obligation of husband is personal. Wife have a right. Therefore, language is clear and non-doubtful. Section 18 subclass 2, wife is also entitled to live separate without forfeiting the claim of maintenance. Enjoy the maintenance but live separate. And third, when the wife is not entitled, when wife is converted from Hinduism and she is unchaste, she cannot claim any kind of maintenance, friends. Now, friends, maintenance of widowed daughter-in-law. Friends, maintenance of widowed daughter-in-law, a Hindu wife, whether married before or after the commencement of this act, shall be entitled to be maintained after the death of her husband by her father-in-law, provided and to the extent that she is unable to maintain herself out of her own earning or other property, or where she has no property of her own, she unable to obtain maintenance. Friends, when she unable to obtain maintenance from the estate of her husband or her father's or mother, from her son or daughter, if any, or his or her estate. Any obligation under subsection 1 shall not be enforceable if the father-in-law has not the means to do so from any copassionary property in his possession out of which daughter-in-law has not obtained any share, and any such obligation shall cease on the remarriage of the daughter-in-law. Now friends, we can analyze the provision of section 19. Section 19 of Hindu Adoption and Maintenance Act provided that a Hindu wife, whether married before or after the commencement of this act, has the right to be maintained by her father-in-law after the death of her husband. Father-in-law's obligation to maintain widow daughter-in-law arises if following conditions are satisfied. First, she is unable to maintain herself out of her own earning or other property. And if she has no property of her own, cannot get maintenance from her deceased husband's assets, her own father and mother, her children, son and daughter, or their interest, or their estate, means property of her children. Friends, section 19 also further clear that the father-in-law's obligation to maintain her is not enforceable if he does not have the means to do so from copassionary property that is in his possession and from which daughter-in-law has not already received a estate. The obligation ends if the widow daughter-in-law remarries. Means friends, obligation of the father-in-laws is not personal in nature. Means father-in-law only responsible in limited cases, and widow daughter-in-law may lose right when remarried with others. Friends, in a case of Kansir Lal versus Pusparani, Calcutta High Court held that section 19 is equally applicable to a daughter-in-law governed by Daibhag school. In a case of Animuthu versus Gandhi Mal, the Madras High Court in the year 1977 held that a right to claim maintenance in subsection 2 cannot be enforced even if daughter-in-law, through entitled to claim the share of the joint family property, does not choose to do so. Father-in-law's obligations is very clear. You must understand its nature. Date of becoming widow. The liability of father-in-law is started when she become the widow. So long as the status of wife exists, she can claim maintenance from her husband. And limits of right is when she married again, she can, because section 5 subclass 1 is not applied on her, the rights cannot be enforced under section 19. Now friends, maintenance of children and aged parent. Subject to the provision of this section, a Hindu is bound during his or her lifetime to maintain his or her legitimate, illegitimate children and his or her aged or inferred parents. A legitimate or illegitimate child may claim maintenance from his or her father or mother so long as the child is minor. The obligation of a person to maintain his or her aged or inferred parents, daughter who is unmarried, extend in so far as the parent or the unmarried daughter, as the case may be, unable to maintain himself or herself out of his or her own earning or other property. In this section, parents includes a childless stepmother also. Friends, a Hindu is legally bound to maintain both legitimate and illegitimate children, either son or daughter, and also bound to maintain aged and inferred parents during his or her lifetime. A legitimate or illegitimate child can claim maintenance from either parent as long as the child is minor. The duty to maintain aged or infant parents or unmarried daughter exist only if they are unable to support themselves through their own income or the property. The term parent also includes childless stepmother. In Kalla Mistry case, Madras High Court held that a claim for maintenance under Section 20 can be made by an illegitimate child born out of adulterous intercourse. But the same is rejected by the VKV Sarma versus Indira Sarma, where Supreme Court concluded that the children of adulterous relationship cannot claim maintenance, because if we are going to provide anything to the children out of adulterous relationship, we are diluting the interest of legitimate son. Friends, Section 16 of Hindu Marriage Act granted legitimacy of children of void and voidable marriage. Means there must be a marriage. Marriage may be void, may be voidable. But if you have a concubine adulterous relationship, their children are exist, then such kind of children cannot take advantage, because Supreme Court ruling in the Indira Sarma versus BKV Sarma case. Moninder Singh case, neither of the parent can escape the liability by raising the plea that responsibility of maintenance has been taken over by other parent. So this is the section 21. So now friends, we concluded section 18, 19, 20 and 21. Now friends, 22, maintenance of dependent. This list is very exhaustive list friends. Subject to the provisions of subsection 2, the heirs of a deceased Hindu are bound to maintain the dependent of deceased out of the estate of inherited by them from the deceased. Where the dependent has not obtained by testamentary or intestate succession any share in the estate of Hindu dying after the commencement of this act, the dependent shall be entitled, subject to the provision of this act, to maintenance from those who take the estate. The liability of each of person who takes the estate shall be in proportion to the value of the share or part of the estate taken by him or her, notwithstanding anything contained in subsection 2 or subsection 3. No person who is himself or herself a dependent shall be liable to contribute to the maintenance of other if he or she has obtained the share or part of value of which is would, if the liberty to contribute, if the liability to contribute were enforced, become less than what would be awarded to him or her by way of maintenance under this act. Friends, the heirs of deceased Hindu are required to prove maintenance to the deceased dependent from the estate they inherit. If the dependent does not receive any share from the estate through testamentary or intestate succession, they are entitled to maintenance from those who inherit the estate. The responsibility of providing maintenance is divided among the heirs based on the value of share they inherited. However, if dependent has obtained a share or a part of value of which is they are not required to contribute to the maintenance of other if their share or its value would be less than what they would receive in maintenance under this act. Friends, section 21 also talks about the list of dependent, and the list is exhaustive list friends. For the purpose of this chapter, dependent means following relatives of the deceased: his or her father, his or her mother, his widow, so long as she does not remarry, his or her son, or the son of his predeceased son, son of the predeceased son of predeceased son, great grandson, they are covered under the definition of the deceased dependents. His or her unmarried daughter or unmarried daughter of his predeceased son, and so many are defined as a dependent of deceased, friends. His widowed daughter provided, and to the extent that she is unable to obtain maintenance from the estate of her husband, from her son and daughter, if any, or his or her estate, from her father-in-law or his father, or the estate of either of them. Any widow of his son, of a son of his predeceased son, also comes under the definition of dependent. His or her minor illegitimate son, so long as he remains a minor, his or her legitimate daughter, so long as she remains unmarried. The term dependent referred to certain relatives of the deceased. This includes deceased father and mother. It also includes the widow of deceased as long as she does not marry. Friends, a son of predeceased son, and son of predeceased son is considered the dependent. In a case of great grandson, from his father's or mother's estate, and unmarried daughter and unmarried daughter of predeceased son also considered as a dependent of the deceased, but their rights are dependent. She not remarry again, and only if she cannot get maintenance from his own parents or grandparents' estate. The widow of daughter is a dependent if she cannot obtain the maintenance from her father's estate or from her children's or their estate, or from her father-in-law or his father or their estate. Friends, a minor illegitimate son is a dependent as long as he remain a minor, and an illegitimate daughter is a dependent as long as she remains unmarried. Friends, now the question is amount of maintenance. Friends, Bombay High Court in a case of Ekadeswari Bhushan Sahib observed that no fixed rule can be laid down as to the amount of maintenance which each claimant is to have. Each case is to be judged according to the nature of its circumstances. Maintenance depends upon the totality of all the facts, the amount of free estate, the past life of married party, a survey of the condition and the necessity, the rights of the members, on a reasonable view of the change and circumstances possibly required in future, regarding being of course had to the skill and mode of living, to the age, habit, wants and class of life of the parties. Friends, means amount of maintenance will be dependent on the various factors, which includes variety of factors. What kind of life is going on, what kind of necessities are there, what are the prerequisites. On while considering everything, the amount of compensation may be fixed by the court. Section 23 provides the provisions for the amount of compensation, and section 23 provides that the court has discretion to determine the amount of maintenance, but in doing so it must consider the factor listed either in subsection 2 or subsection 3 of the section, as the case may be. Section 23, amount of maintenance, it shall be in the discretion of court to determine the whether any, and if so, what maintenance shall be awarded under the provisions of this act, and is doing so, the court shall have due regard to the consideration set out in subsection 2 or subsection 3 as the case may be, friends. Subclass 2. In determining the amount of maintenance, if any, to be awarded to wife, children, aged or infant parents under this act, regard shall be head to position and status of the parties, reasonable wants of the claimant, if the claimant is living separately, whether the claimant is justified to do so, the value of claimant property, and any income derived from such property or from the claimant's own earning or from any other source, the number of persons entitled to maintain under this act. So these are the factors, friends. Now section 23 subclass 3, in determining the amount of maintenance, if any, to be awarded to a dependent under this act, regard shall be head to a net value of the estate of deceased after providing for the payment of his debt, the provision, if any, made under a will of deceased in respect of the defendant, of the dependent, the degree of relationship between two, the reasonable want of the dependent, the past relationship between the dependent and the deceased, the value of the property of dependent and any income derived from such property or from his or her earning or from any other sources, the number of dependent entitled to maintenance under this act. Section 24 provides that only individuals who are Hindus can claim maintenance under chapter 3 of this act. The claimant of maintenance should be a Hindu. No person shall be entitled to claim maintenance under this chapter if he or she has ceased to be Hindu by conversion to another religion. And who is Hindu, which is defined in section 2 of this act. Hindu includes both Jain and Sikh, friends. And wider definition of Hindu is already discussed in the previous lecture, friends. On that basis, you can determine who is entitled to be maintained, friends. Now in this light, friends, we can think about certain question. Can a wife who is living separately from husband still claim maintenance? Under what considerations? What are the key factors the court considering while determining the amount of maintenance? Friends, by this I want to summarize my entire discussion of this lecture. Friends, especially we focus on the rights of wife. We also focus the right of widow daughter-in-law. We also focus the rights of children's son and daughter and the aged and infant parents. We also discuss the rights of dependent. Friends, husband's liability is personal, wife have a right, and wife is also entitled to live separate and claim maintenance. But in a case of daughter-in-law who is widow, the father-in-law liable only in the case when the father-in-law have property. The liability of father-in-law is not personal in nature. Friends, in a case of children and infant parents, friends, so long as the child is minor, then person is liable to maintain them. And in a case of aged and infant parents, if they are not able to maintain himself, then a person is liable to pay and maintain the fathers and mothers also. Friends, the list of dependent is also very high. Suppose if you are receiving the property from anyone and a person have liability on his shoulder, then if you are receiving the property, you are under the obligations to maintain their dependent, and the list of dependent is a very lengthy list. Friends, section 23 talks about that what court should consider when the court is going to award maintenance, friends. Subsection 2 and subsection 3 of 23 is very useful in this regard. What should be considered and what not should be considered. Suppose, friends, if you already have different kind of liability, then amount cannot exceed more than your liability, friends. And section 24 let down thumb rule that Only Hindu is entitled to claim maintenance under this act, no other person, friends. By this discussion, friends, I concluded my lecture on the maintenance. Friends, thank you.